video conferenced across multiple sites across Victoria. So it's very exciting. We've got in excess of 80 attendees today, either that we can see through video conferencing or who are coming in through a Scopia system. My name's Sally Nielsen and I'll be your facilitator today. First, I'd like to take this opportunity to acknowledge the traditional owners of the many lands that we are meeting on here today and pay my respects to their elders past and present. Before I introduce today's speakers, I'd just like to do a little bit of housekeeping. We're linking to our sites, and if possible it'd be great if all sites have their microphones muted during the forum. We tend to can get a bit of a feedback loop, so it just assists with the audio, and then we can actually unmute during question time at the end of the forum. We have three larger sites today, Geelong, Warrnambool and potentially Horsham, which we'll cross to at the conclusion of the speakers for questions, and then any of the attendees at the other sites, you'll see that there is a text mobile number to actually text questions through to, and if you have a pen, I'll just actually read that mobile number out and feel free to text through any questions throughout the forum. It is 0427 659 140. So I'll just repeat that for you. 0427 659 140. So it's wonderful to be joined today by a wide-ranging audience, not only geographically but also from both corporate and community sectors. Corporate responsibility is of far greater interest in Australian company boardrooms than it was 10 years ago. The latest annual Corporate Responsibility Index has revealed. In 2004, only 65% of companies studied regularly discussed corporate responsibility issues at board meetings. This has now risen to 98%, while 83% have a corporate responsibility committee which gives recommendations to the board. Only a third of companies reported that their board has formally reviewed and approved specific actions and discussed progress of key corporate responsibility issues. Business and Community Chief Executive Stephen Howard commented that it's crucially this shift has been driven by responsible leaders. Apologies to the other venues. We've just had Echuca join us. We're very excited. We've got quite a large number signing in from a remote location up at Echuca. So apologies for that delay, but it's great that we've got them joining us today. So I was just at Echuca just introducing us to two speakers today, Paul Geyer and Sarah-Jane Christensen. Sarah-Jane is a lawyer with over 20 years' experience in the provision of legal and public company secretarial solutions for leading corporate organisations. Sarah-Jane advises on legal and governance issues for boards across all sectors, with a particular focus on the not-for-profit sector. She was formerly a senior fellow at Monash University, lecturing on directors' duties and corporate governance for postgraduate law students, and accredited facilitator with the Australian Institute of Company Directors. Sarah-Jane has been a non-executive director on the board of Cougar Energy Limited and vice chair of Carey Baptist Grammar. She is currently a non-executive director of the Australian Business Volunteers Limited and a private family business. So we're very excited to welcome them both here today. As I explained, if all venues could have their microphones on mute just to assist with the, limiting the feedback loop, and then after the speakers we'll actually go to question time, and you can actually text your questions through to that text number coming up on the screen. I'll just repeat it one more time just before we go to the speakers. 0427 659 140. And with that, I'd like to introduce Paul Geyer, who will be our first speaker.
Thanks,
Welcome,
Sally.
Paul.
Thanks, Sally. I might say right from the outset, I grew up in Sunnycliffs, which is just on the outskirts of Mildura, on a fruit block. So talking about regional Victoria and places like Echuca being remote, it doesn't actually feel that remote to me. It feels quite normal. And many years ago, I was doing a site visit of GP clinics in the UK, and I visited a GP who was 26 miles from Sheffield, who described himself as a rural and remote GP. And I thought, 26 miles, that's probably from Melbourne to Frankston, hardly remote in the scheme of things. But this sort of shows you that being regional often is a state of mind, and I can see this technology certainly narrows the distance. Our aim today is to give you a really broad overview of directors' duties and talk about some of the interesting things that are occurring in directorship and some of the changes that are underway, and some of the sort of housekeeping things that you might want to think about for your boards. I'll say right from the outset, governance is a surprisingly complex topic with lots of grey. Any particular area of governance, such as the legal aspect or the accounting aspect, is a body of knowledge in its own right. So if you've got any issues at all that this presentation pops up in your mind, you should think about seeking proper technical advice rather than using our overview and generalised statements as really thorough guidance for your particular situation with your particular board. So to really start, a director holds a position of accountability. It surprises many people, but there are over 500 laws that deliver personal liability to directors for corporate breaches. There are 500 laws is an extraordinary number, and it probably defies most people's ability to actually understand their full breadth of responsibilities given that many laws. But it's this notion of being held to account for corporate breaches which troubles many people, that something that can occur in an organisation that you're a board of, that you have no understanding of, no knowledge of, but still be held personally liable for. And it creates a lot of pressure on directors to perform. But one of the fundamental notions of being a director is about being a fiduciary. And it defines what a director's role is and the board's obligation. And I think one of the nicest quotes about a fiduciary, I think, is that last quote, which comes from Jane Walton. Fiduciary duty requires one of the highest orders of thinking, beyond thinking and doing for self, thinking and doing for a close group, family, friends and other entities. So really, it is moving into this area of ethics, and if you can apply an ethical framework to being a director, it will assist you with your accountabilities. The word fiduciary itself comes from Latin, meaning faith and trust. Right, very important concepts around faith and trust. These are the summary of duties that come straight out of the Corporations Act. Obviously, fiduciary right from the outset, a duty to act in good faith in the best interests of the company, a duty to act with care and diligence, not to make improper use of information, not to make improper use of position, to avoid conflicts of interest, to act honestly. You sometimes wonder why that particular one has to be stated, but clearly it's needed. And to not trade while insolvent. And of course, trading while insolvent can lead to criminal punishments. The important thing to look at when you look at this summary is that these aren't particularly complex notions. My 11-year-old son can get his head around most of these dot points, while I'd probably have to explain to him what insolvent trading is. But the first dot point around acting in good faith, and only in the interest of the company, is something he can understand. So these aren't particularly complex terms, and they really do form the foundation of most board roles. I usually say that if the Corporations Act doesn't get you, common law will. And the common law requires that a director must become familiar with the company's business, monitor the company's activities and policies, and maintain familiarity with the company's financial status, including by regularly critically reviewing financial statements. The recent case with Centro really highlights this last point. it requires all directors to be able to read financial statements. It doesn't assume that every director has to be an accountant or has to have a detailed understanding, but it assumes a basic understanding that everyone sitting around a board table can review the financial statements and do that with a critical and independent mind. One of the issues that we see coming up a lot, and we get lots of questions about from members and also non-members, is around conflict of interest. And I like to begin it from a particular point of view, which is around the notion of being independent. And this quote, I think, is really appropriate. A non-executive director, I've used the acronym NED, a non-executive director is free of any business or other relationships that could materially interfere with the independent exercise of their judgment. If you're following what's going on in New South Wales, you see this playing out where suggestions are being made that some politicians have lost their independence because they're being too heavily influenced by gifts or favours given by lobbyists. The ASX Corporate Governance Council is very clear about this. Directors must act fairly and impartially, avoid bias, discrimination, caprice or self-interest. And you can see the basis of this comes from the Corporations Act. You sit on a board of a company and only act in that company's interests. You're not there to act in the interest of outsiders to the company, a particular class of shareholders or a particular group of shareholders, or in not-for-profit's case, a particular group of members. You're there to act for the whole organisation and its best interest. The next quote comes from the State Government of Victoria, the Victorian Public Entity Directors Code of Conduct. And it goes to a little bit more detail. Do not use your position as a director to seek an undue advantage for yourself, family members or associates, or to cause detriment to the public entity. Ensure that you decline gifts or favours that may cast doubt on your ability to apply independent judgment. And the last Premier of New South Wales probably fell foul on that concept. I like to think about this in not-for-profits as being a little bit more complex than private companies or commercial companies. Because in commercial companies you're dealing with financial interests, and often that can be very easy to be clear whether or not someone's actually going to financially gain or lose from a particular decision-making process or decision that's underway in the boardroom. But of course in not-for-profits, when you're dealing with issues around mission, role, members' interests, who benefits from the not-for-profits activities, it's beyond money. And so you really are at the heart of around, is someone sitting at the table with an independent mind, or are they being unduly influenced by others around them? So the issues around conflict of interest often settle around how you should handle them. But also around a related notion around conflict of duty. If you're on the board of two organisations, if you're a director of two organisations, you have a duty to both, to act only in the interest of one. So when you're sitting on the second board, you're now conflicted between acting in two interests when they start to overlap. This often causes a challenge, and you can see that second point around being a representative, that you can't be a representative. You can't represent organisation X on organisation Y's board because you have a duty to only act in the interest of one organisation's board. And there lies the great challenge of being a representative. And fundamentally, you can't sit on a board acting as a representative. So the process, most boards will maintain a register of interests, of commercial interests of their directors. The standard thing is that when you declare an interest that you exit the room. But I think there's some sub-points in here which are really important to understand. As soon as a conflict has been identified by a director or someone else on the board, it must be disclosed. Transparency is absolutely essential. The beginning point of trust is around open disclosure of when you think you're losing your independence and your judgment could be swayed. But the last point from Simon Longstaff from the St James Ethics Centre is key. The moment that an individual director discloses they have a conflict or they are no longer capable of exercising judgment, they are not the person to decide how it is to be resolved. It's the others around the board table who decide how that conflict is to be resolved. And you can see, when you look at the bottom part of the slide, there are some options for how the board can decide a conflict is to be resolved. The director could leave the room. They could stay, observe, remain silent and not vote. They can contribute and then not leave, and so on and so on. But it's important that the board decides, not the individual who is conflicted. So on that note about conflict of interest, I might hand over to Sarah-Jane.
Just in the context of conflict of interest and the director's duties generally, it's always nice to look at an example of where this has sheeted home. And a recent example that came out of the courts last year was down at UDI and Gillies. And this was a situation where the managing director had arranged with the chief financial officer for 2 payments to be transferred to him to pay for a boat. And the managing director did this because he felt that he was entitled to these payments to be made by the company as an advance on his bonus. But the managing director did not disclose this to the company, and it was about some $200,000. Subsequently, the company sought to terminate the managing director's employment, and this transaction came to light. And they used this transaction as a basis for terminating his employment for cause. And the managing director appealed and went to the New South Wales Court of Appeal. And what the Court of Appeal said, which is pertinent to some of the concepts that Paul's discussed, was that by taking those sums of money without disclosing it to the board, the managing director had, irrespective of his employment contract, had acted in breach of his director's duties. It goes back to those duties of disclosure, of good faith, improper purpose. And needless to say, he was unsuccessful in having his contract, receiving a payment of compensation for wrongful dismissal. You'll notice that on our agenda we also wanted to provide an update on some developments that are happening in the area of governance and directors' duties, and no more pertinent is the area in relation to social media. And a couple of instances here that you'll see on your slides. One of them is a case of Sea Folly and Madden. Sea Folly, as those of you may be aware, is a swimwear company, and Madden was the owner of a small swimwear company who thought that Sea Folly was imitating her designs. So she posted on her website the comment, "The most sincere form of flattery," and then had pictures of the designs she felt that Sea Folly were imitating. Sea Folly were not happy about this because they hadn't imitated her designs, and they sued her successfully, claiming misleading and deceptive conduct. What was interesting here, though, is that Madden thought that she was putting these on her personal website and that it was just a statement of opinion. The federal court did not agree and said that by putting this on the website, she was making a reckless and public expression that could be subject to misleading conduct, as was found against her. What's interesting there is companies, even very small companies, have to be very conscious about what they're putting on their websites. Interestingly, as you'll see on your slide there, the Advertising Standards Bureau has recently said that it will be looking at companies' Facebook sites and applying the same standards that it would apply under the provisions of the Advertising Code. The issue in relation to Facebook sites is also quite pertinent when it comes to employees. And in the instance of Lync and Stutzel, Mr. Stutzel was an employee of the Lync group, and he posted some very perhaps disparaging comments about his manager on his personal Facebook site, and was dismissed by Lync as a result. Mr. Stutzel took proceedings against seeking reinstatement and the full bench of Fair Work Australia supported his claim. And they supported his claim on a couple of fronts. One was he was an elderly gentleman and he claimed he didn't understand the implications of putting these comments on Facebook. Secondly, though, and perhaps more pertinent, and particularly to those of us who are directors on companies, is that there was no social media policy within Lync advising its employees of the inappropriateness of such conduct. So as a result, Mr. Stutzel was successful in pleading that he was ignorant and getting his job back at Lync. Some of you may be aware, because there's been quite a lot of media and commentary at the moment in relation to changes to the Australian privacy principles. Without going into them in too much detail, it is worth noting, though, that they have a much more far reach than their predecessors, which were the national privacy principles. Significantly, any business that has a turnover of more than $3 million will now be subject to the Australian privacy principles. And that's a cause close to my heart as a former director of an independent private school, and some of you may be involved in the private school sector. Significantly, some of the requirements which you have up on your screen, but one of the more pertinent ones is to ensure that there is a privacy policy and that that is disclosed to those. So in the school context, that you'll be making your privacy policy disclosed to parents and students alike. And some of you may already have noticed, I know I have noticed, that some organisations are now asking for consent to be able to disclose information that in the past they had not sought that consent. Interestingly, I'm a shareholder of Westpac, and I received something in the mail only yesterday saying, do I consent for my details to receive some of their direct marketing material? That's in response to these new privacy principles, where you must obtain somebody's consent before you provide them with direct marketing material. There are some exceptions, but generally you need to get their consent. And also, coming back to the issue in relation to websites, which is worth noting, is that it's important where you're using websites to distribute information that you provide an option for people to opt out, so they can say they no longer want to subscribe to your services or receive your material. The big stick at the end of this is that the Australian Privacy Commissioner has a lot more powers, and of course there's a maximum penalty, as you can see on your screen, of $1.7 million, which could be quite painful. I just want to now move on to foreshadowing some of the things that are happening in the public company space. And while some of you may not be involved in the public company space, I always find it intuitive to look at that area as an indication of what could happen and flow down in the non-public company space. Because what we've seen over the last 4 or 5 years have been advancements on corporate governance issues that apply to ASX listed companies that are starting to filter through even to the not-for-profit sector. So in this context, there were some changes that were made to the Australian Stock Exchange corporate governance principles in March this year. Some of the more interesting changes was the introduction of a requirement that boards undertake appropriate checks before they appoint directors. So they undertake appropriate police checks, reference checks, etc. That directors checks, etc. That directors have contracts in place with the organisation and also senior executives. In my experience, particularly in the not-for-profit space, it's common to have contracts for your employees, but often the directors themselves don't have contracts in place. Interestingly now, the role of the company secretary has been, for some organisations, elevated to a requirement that they report to the chair. That's seen to be good governance practice rather than having the company secretary report to the chief executive officer, or as often the case in the publicly listed sector, the chief financial officer. And Paul mentioned earlier about the issue of independence in the context of directors' duties. Interestingly, there have been changes in this area in terms of corporate governance principles as well. And now under the ASX guidelines, boards must disclose, they've always had to disclose whether they consider a director to be independent, but the criteria for independence has been broadened. It's been broadened to look at family ties that a director may have with the organisation, and also a broader sweeping condition has been included where the board consider the length of service of the individual and as to whether that would compromise independence. Interestingly, in the precursor to these principles, when the discussion paper came out, it was suggested that a period of 9 years would compromise independence, and you'd have to explain why you thought a director could continue to be independent if they'd been on the board for more than 9 years. That seems to have been dropped in the actual principles that have been released, but that provides a good guidance as to where the thinking is from the ASX. Also interestingly is that in terms of executive remuneration, which many of you will have heard about, it's been quite a topical area over the last 4 or 5 years, there is now a requirement in the corporate governance principles that there is disclosure of any clawback policies you may have in relation to your executives, and that there be provisions to claw back bonuses that have been received where there has been serious misconduct, or pertinently where there's been a material misstatement of the financial statements of the organisation. So similar to a Centro circumstance, for example, there you'd be able to claw back any bonuses that may have been awarded prior to the disclosure of the issues in relation to their financial statements. Also in relation to the corporate governance guidelines, there have been some changes in the area of finance and risk. One of them, the first stop point, is in relation to financial declarations from CEOs and CFOs. Under the Corporations Act, the CEO and CFO are required to provide a declaration to the board that the financial statements have been provided, have been prepared in accordance with the Corporations Act and accurately reflect the affairs of the company. That statement is only required once a year in relation to the end-of-year financial statements. Under the ASX Corporate Governance Guidelines, CEOs and CFOs will be required to provide that whenever they are declaring the financial statements for any period of time. Quite commonly in the publicly listed space, that would be for half-yearly statements. There's also been some changes in relation to risk committees, and I know that this is a topic dear to Paul's heart, so I might introduce Paul just to have a chat about that.
I don't know where to start after that introduction. I have to confess, as a former CEO, I used to hate doing risk management plans, and so that's why I've stumbled at that introduction. I think the interesting thing about risk is that the Corporate Governance Council's come out recommending that boards have risk committees. Most boards, though, are moving down a pathway of combining audit and risk together, recognising that they are not separate, that they actually do interrelate with each other, and understanding your risk exposures is really important for the audit committee. And so we see organisations combining audit and risk committees as one, and so their calendar spreads the task of audit and risk over a whole year together. We also see organisations where the audit committee will meet for a couple of hours, and immediately after, the same people meet as a risk committee. So they are consciously trying to integrate audit and risk together. The second point there around the board's annual review of the risk management framework, most organisations are moving down a pathway of having a risk management plan and undertaking some sort of governance processes around that review. You know, the important thing is for boards to clearly understand the distinction between strategic risks, compliance risks, and operational risks, and to understand how management is approaching the mitigation of those risks. There is no value for the management team or the board in receiving, the dashboard with lots of colours on it, unless they're really clear that management has got a system or process in place for managing the key risks of the organisation, and the board understand that management is on top of that. The challenge for all directors is that you can come up with the most highly detailed list of risks for an organisation, but they may never be the ones that actually cause you the greatest strife. And so you've got to have some sense of the resilience required in an organisation to overcome changes in the external environment. You've got to have your antenna up to understand what's occurring that is going to have a strategic impact on your organisation. And that's just good director behaviour. The fourth point there around the Corporate Governance Council's recommendation to have an internal audit function. As a director, I'm a really big fan of internal audit. Whether if you're large enough to have an in-house capacity, or for most organisations, and certainly the ones that I'm involved in, you're looking to outsource that to a specialist advisor such as an accounting firm or a risk management firm. But it's worth going out and getting quotes because a single sweep of review of one particular area of your function is actually not that expensive. But from a director's perspective, external audit is really a process designed for shareholders and members to ensure the integrity of the financial statements in the annual report. Internal audit's a process that directors give direction to review the internal systems and processes to understand that they're meeting the requirements of the organisation. I've got some great experiences of internal audit undertaking a review of purchasing controls, and in one particular department, we discovered that the organisation had 250 staff and 180 mobile phones. They didn't know who had the mobile phones. And in my view, there's a lot of teenage kids roaming around Melbourne using our organisation's funded mobile phones. And that's a classic example of the benefit of having a good, sound internal audit process. And the last one, Sarah-Jane.
The ASX Corporate Governance Council has also recommended that publicly listed companies disclose economic, environmental and social sustainability risks. This is a reflection on what's happening in the UK, because in the United Kingdom, they've actually changed the equivalent of our Corporations Act requirement that directors act in the best interests of the corporation. They've actually changed it with what they call the enlightened shareholder value principle. And this is where they actually go in to explain what is in the best interest of the company, and they require directors to have regard to longer term and various corporate social responsibility factors when making their decisions. A much more prescriptive approach than we adopt in our law. It's interesting that the Corporate Governance Council has picked that up in one of its corporate governance recommendations. Of course, the area of diversity always warrants some discussion, given, as said on the slide, the glacial progress that is happening there in relation to particular gender diversity on boards. In that context, though, it's worth noting that the ASX Corporate Governance Council has perhaps toughened up its disclosure requirements on the gender diversity issue by requiring more measurable goals to be disclosed by organisations. Also for organisations to have regard to the women in their senior executive ranks, as well as throughout the organisation. In terms of the disclosure, though, this is happening generally across the corporate Australia with the introduction of the requirements under the Workplace Gender Equality Act. These come in place in the next financial year, 2014 to 15, and for any employers with more than 100 employees, they will need to disclose against 6 gender equality indicators. And publicly listed companies will no doubt fall within that, and they can satisfy this requirement by disclosing against those indicators. But to give you a taste for some of those indicators, it requires companies to disclose the gender composition of their workforce by occupation, classification and employment status, to look not only at the gender composition of boards or their governing entities, but also go forward and do audits of the remuneration of men and women throughout their workforce who are performing comparable roles. Look at the employment conditions that are on offer, particularly in relation to flexible working arrangements, and also to disclose what kind of employee feedback or staff survey arrangements they have in place to get their employees' views on gender issues. So that's a factor that's really coming to the fore now. Briefly, some other new developments are in the area of bribery and corruption. And in this context, this is pertinent because our federal criminal code makes bribery a criminal offence. However, under the Australian provisions, what's commonly known as facilitation payments, they do not constitute an offence, provided that there is appropriate record keeping in relation to those and the benefit is of a minor nature. It's interesting that we always harken back to the Australian Wheat Board example, because there Mr. Lindbergh, who was the CEO of Australian Wheat Board, he admitted to improper business practices because as the managing director and CEO, he had approved some of the payments that were made. The court, when considering what penalty would be applied to Mr. Lindbergh, made the point that by not having appropriate systems in place and approving those payments, he had actually acted improperly and in breach of his common law duties. So that's hearkening back to the principles that were discussed earlier by Paul. And just when you thought, well, this isn't going to apply to me because I'm on the local footy club, we have to think about that again, because it's also going straight through to sporting organisations, and as we'll touch on in a moment, not-for-profit organisations as well. Interestingly, in relation to sporting organisations, where it's a national sporting organisation with more than $5 million worth of funding, the federal government is now putting in place certain requirements in relation to the governance of that organisation, which you can see there on your screen. Interestingly, they will now need to incorporate and become companies limited by guarantee. That would mean that they become public companies, and so the laws that apply to public companies listed or unlisted, the ones that apply to unlisted public companies, would equally apply to them. And interestingly, the diversity issue is also gaining some precedence, requiring 40% female board representation by 2015. Conscious of time, I might just switch. Oh no, I can't go without mentioning my poor beloved Bombers. I am a long-suffering Essendon supporter, and that's why this slide is in here, because you will all recall the report that Switzkowski undertook in relation to the governance arrangements with respect to Essendon and, as some people call them, the Peptide Boys. In that context, though, it's important that there were three of the recommendations Switzkowski made, and one of them was to ensure that your organisation passes up bad news to the relevant executive and board level. And that was one of the concerns they had in relation to the Essendon Football Club, that the bad news was not seeing the light of day. Secondly, that the policies and procedures for the organisation are regularly reviewed and updated. And this is something boards need to ensure is done, and sometimes they have a direct hand in it, to sign off on the relevant policies and codes of conduct. And thirdly, whatever your organisation, ensuring that the key risk drivers, such as Paul identified earlier, are being reported through to the board. And in the case of the Essendon Football Club, that related to issues such as the attendance of players and ensuring that you get some of those players and members of the leadership group attending board meetings so you can get some visibility on some of the key issues affecting the club. I mentioned earlier in relation to the not-for-profit area and how some of the governance issues are now applying in relation to not-for-profits and charities, particularly with the onset of, the introduction of the Australian Charities and Not-for-Profit Commission. Now, whilst it's still a little bit up in the air as to what's going to happen with the Commission with the new coalition government, it is still in effect. And those of you that are directors of not-for-profit organisations will be familiar with the reporting requirements that have now been introduced, particularly in relation to charities. Significantly, charities will now need to provide statements to the Australian ACNC and must comply with certain governance standards. So that's when I said earlier, we all thought that it wasn't going to apply to us because we're just a local charity. Well, that's not the case. Some of those governance standards are set out on your slide, And significantly, it's important for not-for-profits and charities to be able to demonstrate that they have a purpose, and what is their purpose and what's their character. Now, a common way of doing that is through websites or publications to their members, but it's also important that they're quite transparent to their membership or members base as to how they comply with those purposes. That comes into them being accountable to members. Not-for-profits and charities need to establish some mechanism where there is some accountability back to their membership base. Commonly that's done in the corporate sector through an AGM, an annual general meeting. Many not-for-profits that are public companies limited by guarantee will have annual general meetings, but there may be others that do not, and this is one requirement that the ACNC has now instituted. Interestingly, there is also a requirement that not-for-profits and charities must not act in conduct that creates an offence. The reason why I emphasise that is it's actually saying you must not engage in conduct that creates an offence, rather than you must not create an offence. So that's allowing circumstances where, an example that is used by the ACNC is if they suspect something untoward is happening within the organisation, they can act preemptively. A common example which is used by the ACNC is where they suspect there is fraud. So it entitles the ACNC to then impose itself within that organisation. Fourthly, it's important for organisations to ensure that the people that are running them, and this you can read here, this is usually directors or trustees, are qualified to be able to run them. That means that they're not disqualified, so they're not bankrupts or any other criteria that may apply. That requires a proactive stance by boards to ask individual members to update them annually, semi-annually, whether there's been any circumstances that would cause the members of the board to become disqualified. And finally, you've got the duties of what we call their responsible entities, and you can read in that that's really the trustees or the directors of the organisation. And those duties are very similar to the duties Paul outlined earlier. So if you thought that directors' duties didn't apply to you because you were for a not-for-profit or a charity that may not be incorporated, that's no longer the case. In the context of an update, it wouldn't be an update without mentioning tax. And as some of you may be aware, there have been changes to the tax laws to provide for personal liability to directors in relation to unpaid superannuation. In this instance, it applies very similar to the requirements where directors may be liable if there's been unpaid PAYG tax. And how it operates is that the ATO will issue a penalty notice to a director if it believes that there has been unpaid superannuation or income tax liabilities by the organisation for which they are a director. And the director has 21 days in which to respond. And the director can respond by ensuring the payment is made by the company, or if that's inappropriate, ensuring that the company, or voting with other directors presumably, that the company is placed into administration. What's important in relation to that 21-day requirement is that the ATO will have regard to the director's details that are held with ASIC. So one of the key things I say to the directors I talk with is please ensure that your ASIC details are current, because if you have incorrect address details on ASIC and something like this should be sent to you, that 21 days could easily lapse without you even knowing it. Secondly, though, and perhaps more importantly, is to ensure that you've got some mechanism within your board that you know that these payments are being made on a regular basis. Whether some organisations, I know in the not-for-profit sector, get their CFOs to certify to the board at every board meeting that the income tax liabilities and superannuation liabilities of the organisation have been satisfied. Finally, just moving now to some housekeeping matters. We always think about housekeeping and have a bit of a yawn, but it can bite us when we least expect it. And one of my favourite instances of this, as an old company secretary, is the Weinstock case that came out last year. Poor old Mr. Weinstock, he was the director of a family-owned company. It's a private business, and he wanted to appoint his wife as a fellow director. Prior to then, he was the sole director. He sought to appoint his wife as a fellow director, but it became apparent that his directorship had in fact lapsed, because under the terms of the Constitution, it had the rotation provisions provided that his directorship had automatically lapsed, and he had not, within that time period, appointed a replacement director. I'm not quite sure why ASIC took it upon itself to take issue with this, but they did, and claimed that the company needed to be wound up because it effectively was rudderless. It had no director. Mr. Weinstock was no longer a valid director because under the terms of the Constitution, and he could not appoint another director in those circumstances. Well, this matter ended up in the High Court, and fortunately the High Court used some of the discretions under the Corporations Act to provide some rectification for Mr. Weinstock so that the situation could be resolved. But the lesson here is, who wants to end up in the High Court because we've acted unwittingly in breach of some constitutional provisions? It's a very expensive process, and here it was an uncertain remedy, because to get to the High Court he had to go through the appellate process throughout the New South Wales court system first. So the lesson here, as at the bottom of the slide, is always check the fine print. Be wary of what's in your constitutions, and if you're not happy with what's in your constitutions as a board, don't be afraid to have it changed. Yes, there's a process involved, but it's better to do that than get caught out. And finally, in relation to meetings, the hoary chestnut of minutes of meetings. Many of you will recall the situation in relation to the James Hardy case, where the directors got themselves quite caught up in relation to the minutes of the particular meeting in question. And I often get asked in relation to minutes is how much should you put in the minutes? What is enough? Interestingly, in relation to the James Hardy decision, in those circumstances, the minute that was in question was a pro forma minute that had actually been prepared by the external lawyers. And what that minute had said was the board approved the ASX announcement. And it was as simple as that. It was about a 2-line minute. In those circumstances, the board subsequently said, we don't recall approving the ASX announcement, and that the minute was wrong. That's where the directors on the James Hardy case got themselves into a bit of a knot, because they're saying that the minute was incorrect, yet 6 weeks, I think it was actually 2 months after the relevant board meeting, they had actually approved the board minute, which they subsequently claimed was incorrect. So if you look at that in the context of your director's duties, if the minute was incorrect, why did you approve it subsequently? And if you did approve it subsequently, well then are you acting with due diligence as a director? Having that said, there's been a lot discussed about the whole issue of minutes in that context. The question then comes to what the content of the minute was. And I can see Paul, did you want to add something to that, Paul?
I think there's another issue in this case, which is that the directors commented in court that they had actually not cited the draft resolution that was apparently tabled. And so the issue for directors is, as we all experience, CEOs and company secretaries and others drop things into board meetings. But that process actually requires documentation, because this is what caught out these directors. They denied that the disclosure, the draft disclosure, had actually been tabled. And so because there was nothing written into the agenda or the minutes that it actually was tabled, hence the debate. And then they found themselves in all sorts of strife.
And that comes back to what do you put in your minute. And as a previous company secretary, I think minutes are a great mechanism to protect the board. Of course, they must accurately reflect what occurred, but importantly, my tip for those that are preparing minutes is to be a little bit more expansive than just say the ASX announcement was approved. As Paul pointed out, it would be more important, it would have been more helpful, for example, to have said draft XYZ of the ASX announcement was tabled at the meeting. There was discussion about the draft, some key issues were identified, and then if it were approved, then the board proceeded to approve it. That would have been very helpful in the James Hardie case for the overseas directors, because it would then have been evident, as they argued, that they would not have seen the latest draft because they were phoning in from the United States and may not have had visibility of it unless they had some technology to assist. Whereas those directors, when they said, well, look, we never saw it, the judge quite rightly, and the High Court subsequently quite rightly said, but there's no evidence in the minutes that you did not see the announcement, so we need to take the minute for what it says verbatim. In terms of minute practice, of course, given the James Hardie case, it's got a lot of focus now. So not only are we now looking at the content of the minutes, it doesn't have to be a blow-by-blow content though. It doesn't have to be that Sally said this and John said that. But it does need to be reasonably descriptive to show that the particular issue has been considered. It's now common practice for minutes to be circulated within 7 to 10 days of the meeting, circulated to board members so that they can recollect what was discussed while it's still relatively fresh in their memory. They can provide comments back to the company secretary. And importantly, you need to also keep alongside your minutes, which we've got in here in the second last dot point, an action list, so that you can keep in mind what is outstanding on a rolling basis from meeting to meeting, particularly if meetings are, say, 2 or 3 months apart, which often happens in the not-for-profit space. And finally, touching on the James Hardie instance with the directors who were calling in from overseas, it is important to be clear where people are if the meeting is being held as a through video conferencing or telecommunication, to make that clear. If people exit the meeting, very important for that individual to ensure that it's noted that they were away from the meeting for a particular period of time, because something significant could have been discussed during that time and it will be assumed that they were present. And finally, don't be afraid to have it minuted in your meetings where you haven't got the material before you, so you don't feel comfortable to be able to engage in the discussion. In those circumstances, just have it noted that you're abstaining because you may be calling in from somewhere exotic and you haven't got the relevant board papers, as was the case with the James Hardie directors, so that you have it noted that you can't comment on that and you're abstaining from the discussion, and have that included in the minutes. With that in mind, I'd like to close with one of my favourite quotes from the HIH Royal Commission. You'll all recall HIH being the insurance company that several years ago became insolvent, and members of the board, 2 in particular, ended up serving some time at Her Majesty's pleasure as a result of the activities that took place. There was a Royal Commission into HIH, and Mr. Justice Owen made an extensive report. It goes to 3 volumes long. But he made the following comment, which I thought encapsulates the whole area of corporate governance from my perspective, at least. That is, he said, by and large, the people who were involved in HIH were not inherently bad or in some way set upon being part of a corporate disaster. HIH is a reminder, if one is needed, that a drastic fall from corporate grace can occur if those in charge lose their way. And the whole area of corporate governance is to provide guidance, whether it's through the ASX corporate governance principles, the ACNC principles for charities and not-for-profit organisations, or generally the corporate common law and duties under the Corporations Act, is to provide directors with at least some beacons so that they can seek to find their way. Paul, would you have anything else to add?
Thank you, Sarah. I think we're extremely fortunate today to have the breadth of knowledge and experience in the room. And so with that, I'd like to, of both Paul and Sarah, and I'd like to go to question time. We've had some questions coming through on the text, and I'll just relay that number again, 0427 659 140. And I'll just put a couple of questions to Paul and Sarah that have come through via text, and then we may go to a number of venues, Echuca, Geelong and Warrnambool, as we have a little bit of time available. So in one of the first questions was in relation to the ACNC. Many directors of not-for-profits have regarded the ACNC as useful support, reassurance, transparency on governance issues as well as tax and finance. Will IACD publicly defend the ACNC on good governance grounds against current intentions to wind it up?
I think they mean the AICD.
Yes, the Institute doesn't have a public position on the ACNC. There has been an amount of lobbying behind the scenes around the future of the ACNC. We, alongside the ACNC, published a set of standards and guidelines for governance in not-for-profits, and are very conscious that most surveys of not-for-profit directors indicate 70% or more support for the ACNC and a separate regulator. So while we have not come out publicly, there is a fair amount of work going on behind the scenes, working with the current government on their proposals for the future of the ACNC.
Thank you, Paul. I have another question as well that hopefully I get the wording correctly. Please let me know if I don't. If a chair acts independently in relation to creating a contract for remuneration as well as shortlisting and interviewing and doing the appropriate checks for a candidate for the appointment of a CEO role, and if there are conflicts and the chair did not step aside, what would your advice be in that situation?
Well, I think the first point to make there is it's not, and I'm not suggesting this is the case that's being put forward, but it's not for the chair to decide, it's for the board to decide how to manage that conflict. So the issue would be for the disclosure to be made, and then you'll recall some of the pointers that were on one of the slides as to how the board should decide it should proceed, having regard to the disclosure. In some instances, it might be appropriate that the individual still be involved in the appointment, or it might be better taking it the other extreme for a separate committee to be formed to address it, so there's no suggestion whatsoever that there's been any partisan nature to the appointment, particularly given a CEO appointment, which of course is one of the more significant things the board does. Would you like to add anything?
There's a point of difference between directors and managers that sometimes traps people. Boards act as a whole. You know, the decision-making power a board has is as a collective, not as individuals. And so action-orientated people often get really caught with wanting to make stuff happen outside of board meetings. But they actually can't, because as a director, you're actually working as a collective around the board table, but you're working through management. And this is one of those classic ones where chairs, because of the nature of their role, can get ahead of the board because they're not actually working with the board inside the board meeting. And obviously I would agree entirely around, you know, the issues around transparency and conflict of interest, you know, do need to be declared, do need to be open, and the board itself should be deciding whether or not there is a conflict between the chair in this particular process or not, and therefore how it should be handled. When you start talking about remuneration and employee contracts, my alarm bell in my head would be, you know, this is when you need to go and get legal advice. because you're now moving into contractual situations with employees, and depending on how far this process has gone, and you should be getting appropriate technical advice.
Thanks, Paul. The next question may be even more to add comment on. It's in relation to the director's responsibility for risk. Does the board of the ANZ have responsibility for management decisions regarding Cambodian sugar company found to be breaching environmental and social standards? So whether or not that might be something just to comment on, or...
Look, I won't comment on ANZ and the media that's just occurred in the last 2 days. I'll make general observations that boards will aggregate risk up, and there'll be a class of risk they'll put into a bucket of reputational risk. And I'm quite sure many organisations that deal multinationally will be very conscious of the reputational impact that their organisation or their subsidiaries or their particular stakeholders, contractors, have on impacting small and poor countries. And there's been many examples of that. Nike comes to mind as an example of that. So boards are certainly very conscious of the reputational risk involved when they operate in overseas jurisdictions. And I'm quite sure that in Australian listed boards, they are very aware of these issues and will be on top of them.
I don't really have much more to add, other than to say that whether it's ANZ, National Australia Bank, whichever organisation, they need to and will have identified as part of their risk management process what their risk appetite is, and part of that risk appetite is how they will respond to issues, as Paul has suggested, the whole area of reputational risk. And as long as that framework is in place and they're following that framework, that's one of the duties of the board.
Thanks, Sarah. After this question, I'm going to go to Warrnambool to ask if anybody has a question in Warrnambool, but if you'd like to unmute and ask that question. But just prior to doing that, there's a question here. What is your view on retaining or destroying annotated minutes?
My view is that the board has to form a view, has to form a policy as to what it considers to be appropriate as to how it wants to deal with both board papers and minutes and the destruction of prior drafts or annotations. It is considered to be preferred good governance practice that at least board papers are returned to the company secretary, so that individual directors, you don't have 8, 9, 10 versions of the same board papers with individual directors' annotations. And I would suspect the same would go through with draft minutes as well, and have it all managed through the company secretary so that you have one version. However, it is, as I said, for the board to decide how it wants to manage that process as part of its housekeeping duties.
There's a, if my memory is correct, there was a moment in the OneTel case where I can't remember which of the key players was involved, but one of the lawyers was pursuing him over the meaning of an exclamation mark in his annotations. And there was a knee-jerk reaction to this around destroying your notes and not keeping your notes. And while that's perfectly understandable, the processes around assuring the minutes are an accurate reflection of the discussion become increasingly important if you're destroying your own notes. Because if you have no record that you raised the point about the minutes or raised a particular issue during the discussion, you are now totally reliant upon the organisation's minutes. And so you've got a little bit of a balancing act about whether or not you feel that you fulfilled your duty to assess and accurately record the discussion and the quality of the decision-making process and your personal views, and whether or not the organisation has taken that on board and put them within the minutes. Now, I personally don't keep my notes anymore, in part because if you think about a 7-year statute of limitation, you're now dealing with a large volume of material which you have to keep confidential, and the mechanism of doing that is becoming increasingly harder. And as most organisations have moved over to some sort of board app, you're essentially moving away from paper anyway, so your ability to actually keep annotations is becoming increasingly limited.
I think it's also pertinent to keep in mind that if you are keeping your minutes or annotations, just think how that annotation would be perceived 2-3 years hence. So try and keep them to objective statements.
Look, there's a line that one of my colleagues or former colleagues uses, which is, minutes are a letter to an unknown judge.
Absolutely.
And if you put that in the context of things like the business judgment rule, can you demonstrate via your minutes that a good quality decision-making process was used by the board and that has been minuted? So the more complex, the more conflictual the issue on the board table, the more you want your minutes to show that the board had a good, sound process for making the decision.
And that doesn't mean you have to do a blow-by-blow account, but as I mentioned earlier, if in your minutes it says there was detailed discussion, including, and you point out 3 or 4 salient issues, that shows that there was reasoned discussion about the topic.
You mentioned before with James Hardy, and one of the points that James Hardy did, if my memory is correct, was in a January meeting, they actually requested an additional actuary's report on the asbestos fund, because they were clearly concerned about whatever point was raised in the initial report. So they were demonstrating good judgment and good decision-making processes by requesting additional analysis. And so that was minuted. And so that of course was used in court to demonstrate that they were trying to do what was right. The court found a different scenario, but that particular minute did show that they were trying to do the right thing.
Thank you. And so we'll go to Warrnambool. If anybody has a question in Warrnambool, please move to the mic and unmute it and introduce yourself. Do we have anyone there?
No.
No?
No questions.
Thanks, Warrnambool. Well, we might move over to Geelong. Does anybody have any questions in Geelong? Hello, Geelong.
No questions here, sorry.
No questions. Echuca, would you like to ask any questions? Echuca? No? Well, I still have... Echuca, would you like to ask a question? Just while we're linking in with Echuca, I've got a couple here. So...
Echuca, I've got a couple here. So...
Come on.
Echuca, would you like to ask a question?
Echuca, would you like to ask a question?
No, we're okay, thank you.
Thank you. Great. If you could just unmute again, that would be
Thank you. Great. If you could just unmute.
So I'll just go to a few more of our texted questions. If a new board recognises previous staff payments being under award rates and takes steps to investigate and review to get all staff paid, is that acceptable? For example, it could take 2 to 3 months for a not-for-profit volunteer board. Is that...
I'm not sure I understand fully the detail, but I think it's an important role for boards to ensure the welfare of their staff. And these are often very critical times in not-for-profits when you're struggling for revenue and to drive a surplus. But the board has actually got to stand up and stand with a really sound ethical compass about what is right for the people in their organisation, and then try and put in the processes in place in a timely way that actually reflects what they think is ethically right.
I agree with that, yeah. And also, particularly in the not-for-profit space, boards have to act also in the confines of the resources they have available. And it's not as easy for them to rectify some conduct because of the financial resource constraints they have compared to, say, other corporate entities.
Oh, look, I'll add one more. From my own experience sitting on not-for-profit boards, I've been frustrated with CEOs negotiating EBAs, but at the same time as they're going through their budget cycle and not actually recognising the budgetary impact of their EBA negotiations. And I just think that's poor management. And so, to, as I recall the situation, to, arrive at a board meeting and be told by the CEO, they've now finalised the EBA, but they had to readjust the budget by 3% because that's what the end result was. And I was completely mystified that they've now put us in a more precarious financial situation, and they should have been fully on top of both processes because they're involved in both processes. The board's got to start asking some difficult questions about management performance in those situations.
Thanks, Paul. I have a question here in relation to how can a board legally minimise the effect of one member? So if there is concerns in relation to whether one director acts independently.
I'll start off with one part of this issue, and I'll let Sarah-Jane add some other parts. It's really important during the director selection process that board members understand shareholders appoint or members appoint directors, and only shareholders and members can remove them. Now, the last bit is the bit that traps many people. They actually assume the board has the right to remove directors, but the board doesn't. Directors are appointed to act in the interest of shareholders. So they're appointed by shareholders to act in shareholders' interests. So therefore, only shareholders can remove them. So when you have a maverick director causing you grief on a board, you're essentially left with issues around politely having a chat to them, asking them to go, or you're going to have to go to an EGM or an AGM and ask your shareholders or members to remove them. And that actually can cause enormous amounts of grief. And it puts a huge amount of pressure on the quality of your director selection process. And many people talk about the boys' network and so on. But when you understand that issue, you understand why networking and understanding the quality of a person becomes so important during the director selection process.
Absolutely. I would also add that some more fundamental issues that are worth looking at in this context is ensuring you have appropriate director rotation principles or policies, either in your constitution or the board has agreed it as a group. That allows you to know that you only have a director. A director comes up for re-election every certain period of time. Commonly it's 3 years in the not-for-profit sector. And also that you've got periods of time where maximum tenure. That can assist in that process. But I support what Paul says. It's not for a board to remove a director. And I know of a not-for-profit board that did seek to remove a director, and it worked because everyone was acting in ignorance, and when they suddenly became aware of the fact that what they had done was actually in breach of the Corporations Act, it suddenly caused quite a bit of consternation. So it's so important to have the processes in place for identifying the right director.
And then some other process issues that boards could consider. The role of board evaluation in terms of group feedback about individual performance and behaviour. And then, well before you get to that stage is, when you bring on new directors, what's your process for induction and mentoring them to start giving them feedback around the behavioural standards and values that the board expects. And it's really important to do that well because, the ethical tone that the board sets pervades through the organisation. And so you want to make sure that the board is actually participating in a conversation with new directors around the cultural tone of its meetings, because it will drive through the organisation at some point. And so, my sort of bits of advice would be around, make sure your director selection process is really sound. Think about induction and mentoring to give some feedback on behaviours during the year, and then use board evaluations. These are where I get a lot of calls from people, and they're always messy when they've got issues with an individual director's behaviour and they're trying to remove them. And the standard cry of, this is when you start to think about getting legal advice and think through the process issues about how you're going to go about this.
Interestingly, from a structural perspective, Paul, you may want to comment on this. In the UK now, publicly listed companies, their boards are on 1 year rotation. They have to be re-elected. The whole board needs to be re-elected every year. That's part of their corporate governance guidance principles. So, for example, the board of BHP Billiton, each director was up for re-election 1 year after, on a 1 yearly cycle. The reason I mention that is it comes back to those structural issues as to what your re-election program is for your directors as well, so that that can assist you if there is some difficulty with problematic directors, because you can say to a problematic director, well, you're up for re-election 6 months' time and you're unlikely to get board endorsement.
Yeah, so the way that plays out is at the point during the AGM, the chairman would come out and say the board does not recommend re-election of XYZ.
Yeah.
Yeah.
Importantly, though, the principles we've been talking about are for public companies, so that's public companies or public companies limited by guarantee. They don't apply to private companies.
Thank you. And I think just in addressing individuals' behaviours, I think we may have answered this question, but it's just in relation to disclosure, and if an individual does not believe in conflict of interest or has conflicts in relation to the rest of the board, and some recommendations in how best to manage that. And I think Paul sort of referred to that just prior to this, but whether or not you'd like to add further comment.
I would like to add comment in there, because there is law, and it came out of one of the recent cases that's just suddenly escaped me, but not James Harley, the HIH litigation. There is judicial comment to say that if you as a director are aware that another director has a conflict of interest, or let's call it an interest that hasn't been disclosed, because of course it's for the board to decide whether a conflict exists. If you're aware that another director has an interest and that has not been disclosed, you as part of your director's duties are obliged to disclose that to the board. So in those circumstances, it would be appropriate if I thought that Paul had forgotten, let's just say he had forgotten that he had an interest in a particular matter that we were discussing, that I'd either jog Paul's memory quietly to one side, or if that Paul didn't think there was an interest worthy of disclosure, I might have a chat to the chair. That's where this whole issue of conflict of interest, I think people can get themselves into knots, and I think a more transparent process where directors look out for fellow directors as well is one much better from a behavioural perspective in terms of board dynamics. And let's face it, we're all human and we do have memory lapses, like our former Premier of New South Wales had. So if he can have them, I'm sure we can as well. And it's good if you've got a collegiate enough board for someone to say, oh, Sarah-Jane, didn't you mention 6 months ago that you had an interest in that block of land that we're now thinking about building a ditch over? Something like that.
Thank you, Sarah-Jane. So we might just finish on one final question from Jeanette in Bansdale, unless there's anybody else at one of the venues that might like to ask a question. And she refers to your reference of the importance of contracts for directors, and whether that is also the same for non-remunerated directors.
My view is that it's important that you have some form of documentation in the form, commonly in a contract, or letters of appointment, so that the director knows what is expected of them in terms of, if there's no remuneration, there's also whether they're going to get their expenses paid, what committees, how many they're expected to become members of, and what their time commitments are. And importantly, it is that contractual link between the individual and the company to ensure that the company also fulfills its obligations in terms of having directors and officers insurance available to the director, allowing the director to have access to documentation, although that is enshrined in the Corporations Act. I think it's good practice to have some form of documentation, whether you want to call it a contract or a letter of appointment. I think that's a bit moot. The point is to have some evidence of this is the terms of your engagement, and it's not dependent on the fact that whether you are remunerated or not.
Just on a minor point here, it's, under the Corporations Act, directors are a discrete legal entity. They're not employees. And so when you think about contract, I mean, most people are moving into a space of something they're very familiar with is employment contracts, but because directors aren't employees, it's not going to be an employee contract in that standard form most people are used to. So The letter of appointment is the sort of standard vehicle, and then the level of detail in that will vary depending on the complexity of the organisation.
Absolutely. Thank you. And so fortunately we've really done very well with our time today, and we're going to just draw to a close. I'd really appreciate it if the venues could maybe unmute their microphones, and if we could just join and say thank you very much to both Sarah-Jane and Paul for their contributions today. Thank you.
Thank you. Thank you.
Thank you. And just in closing,
Thank you.
I'd just like.
Just in closing,
I'd like to just confirm that we will be. We'll be sending out copies of the presentation today, as well as a survey to receive feedback from you all. So thank you very much in advance for responding to that survey. And if you have any questions or queries, please feel free to contact us on the mobile number that was provided. And thank you very much for joining us today. And enjoy the rest of the day. Bye-bye. Thank you. Thank you. All right, see how we can mute the line.